Straight ahead on Law&Crime Daily. The Alex Jones defamation trial.
I'm probably going to have to take the fifth, not because I've done anything wrong, but because she's saying she'll find me or put me in jail if I answer these questions truthfully. This is a trap. But I'm walking into this trap because I'm willing to face my accusers.
The defendant takes the stand in his now second civil case after calling the 2012 Sandy Hook shooting a hoax. Plus, a political dispute turns deadly when a man allegedly admits to hitting and killing a teenager with his car while intoxicated. And a suspect is named and charged after a father and his toddler son are found dead in Texas. Then later, the Ohio trial of George Wagner IV.
We were told of 2 victims at the initial notification. By the time we all get there to Piketon, that's when we learned that we had 8 total victims with 4 different crime scenes.
Jurors hear from an agent who processed the 3rd crime scene in the Pike County massacre. Law&Crime Daily covering court cases from coast to coast. Welcome everyone to Law&Crime Daily. I'm your host, Brian Buckmeyer. Defendant Alex Jones takes the stand in the Sandy Hook defamation trial where family members of the victims sue the InfoWars host over comments he made following the 2012 Sandy Hook shooting. The conspiracy theorist appeared inside the courtroom for the first time in his Connecticut defamation trial, which stems from comments Jones made after the Sandy Hook Elementary School massacre back in December of 2012, when the internet show host called the incident a hoax put on by crisis actors in order to push gun control. This lawsuit, brought on by families of the victims of the shooting and a first responder, is the second of 3 suits heading to trial. Jones was already deemed liable in each case in Texas and Connecticut. Now separate juries will determine how much he has to pay the plaintiffs. On Thursday, the plaintiffs' attorneys called Jones to the stand. He was confronted at the start of the day about his previous condemning of the judicial system and questioned about calling the judge a tyrant.
This trial started, and you've been calling it a kangaroo court yourself, right?
Yes.
Right. And you've called this judge a tyrant, correct?
Yes.
Okay. And you actually use that word a lot with your audience. You call people tyrants, don't you?
Only when they act like it.
This is the tyrant pictured here that you've been telling your audience about, right?
I thought you were asking me again about the image or about me believing this is tyrannical. Can you restate the question, please?
Sure. I'll restate it for the 3rd time for you.
Objection to the comments. Move to strike.
This is...
Can we have one motion? Okay, thank you.
This picture right here, that's Judge Bellis, correct?
Yes.
Lasers coming out of her eyes, correct?
Yes.
That's who you've been referring to as a tyrant to your audience, correct?
Yes.
Okay, and you refer to tyrants to your audience a lot, right?
Some.
Right. Tyrants are people who are going to oppress others and strip them of their freedoms, correct?
That's a common definition.
Right. And you've not just called Judge Bellis a tyrant, but you said that this whole thing, what's happening here, is part of a plot, isn't it?
Objection. Motion eliminate.
No, not the whole thing. I think the jury's real.
Jones has been in Connecticut this week preparing to take the stand. He's held multiple news conferences outside the courthouse, bashing the proceedings happening inside.
Here's the problem. The judge says I can't say I'm innocent. The judge says I can't talk about this being a political trial when all it is political, and they've been nothing but political. They put up a picture of a magazine I put out saying Obama wants your guns. And then when my lawyer said, see, this is political, she said, I will sanction you if you say that again. This is not political. They get to be political and then pretend that this isn't political. So since when is someone not allowed to say they're innocent? She said she will sanction me if I say I'm innocent. So when their lawyers ask me questions, I'm between a rock and a hard place. If they ask me questions and I truthfully answer, no, I didn't make money off Sandy Hook, no, I didn't premeditatedly put it out, no, I'm not the first person to question it, I followed what the internet was saying and covering, she will then sanction me. So I'm probably going to have to take the fifth, not because I've done anything wrong, but because she's saying she'll find me or put me in jail if I answer these questions truthfully. This is a trap.
Joining us today is legal analyst Richard Schoenstein and co-host Terry Austin. Richard, objections flew quickly and frequently, a lot about opening the door. Can you break down the argument and why it went the way that it did?
Absolutely. You know, Alex Jones has an endless stream of nonsense he wants to tell you about on the courthouse steps, but also in the courtroom. He wants to testify about how this is all a political witch hunt. But he already waived the liability portion of this case by failing to participate in damages. He's cut off from testifying about a lot of that. His one hope is if the other side opens the door by asking questions that would permit him to give those kind of answers in response. So far, the judge is saying no. So far, the judge is keeping tight control of this trial and of the testimony he's going to give.
Terry, Jones seems to distinguish between what he has said and what people in his organization has posted. So can he be liable for what his contractors post?
Well, one could argue that the comments by either his employees or his subcontractors could be imputed to him. He's at the top of that org chart. He's responsible for his brand, he's responsible for his messages, and he's fully aware that his employees speak on his behalf. They create those images. They talked about the image of the judge. He called the judge a tyrant. They knew he called the judge a tyrant. They created that poster, they put the lasers in the eyes, and they did it because they knew that's what he wanted to do. He didn't say don't do it. And I definitely think that they could easily impute what the employees are saying to what, Alex Jones is saying outside the courtroom.
All right, we'll see how this case continues, as I think Alex Jones and others may continue to testify. And in celebrity news, Los Angeles County has agreed to pay more money to Vanessa Bryant's co-plaintiff, Chris Chester, who lost 2 loved ones in the 2020 deadly helicopter crash, which also killed NBA great Kobe Bryant and several others. Chester has now been awarded nearly $20 million after he and Bryant sued the county over gruesome photos from the crash, which killed his wife Sarah and their daughter Peyton. Both Chester and Bryant sued the county for invasion of privacy, alleging first responders used their personal phones to share photos of their deceased family members. The settlement money includes the $15 million verdict, which was awarded to Chester last month at trial, in which Bryant was also awarded a $15 million payout. In exchange for accepting a higher judgment amount, Chester has agreed to resolve all pending litigation or future claims by him or his family. Also in celebrity news, lawyers for Atlanta music executive Shaka Zulu, who's charged with murder after a June shooting left one person dead, hold a press conference speaking out in response to the charges. Ludacris's longtime manager was one of 3 men shot in the June 26 incident. One of the men, Artez Benton, died of his injuries. Investigators later identified Zulu as a suspect, charging him with murder, aggravated assault, possession of a firearm during a crime, and simple battery. Zulu turned himself in and was released the same day after posting a $200,000 bond. In Thursday morning's news conference, Zulu's attorneys explained his side of the story, saying a friend of Benton's approached Zulu, pulled out a gun, and they got into a confrontation. They said Zulu was trying to de-escalate the situation and defending himself when Benton got shot. His attorneys said there was even an eyewitness at the scene that can corroborate Zulu's story. Zulu's attorneys criticized Atlanta police for not bringing charges against the other people involved in the shooting. Still ahead on Law&Crime Daily, a suspect is in custody in Houston after a father is gunned down, his car stolen, and his toddler is found dead hours later in the back seat. But first, a man accused of vehicular homicide is released on bond after Shannon Brandt allegedly killed a North Dakota teenager over a political dispute. Welcome back. The founder and CEO of MyPillow is suing the FBI after claiming the agency seized his cell phone while he was waiting at a Hardee's drive-thru in Minnesota. In the suit filed this week, Mike Lindell directly names the FBI director, the U.S. Attorney General, and the United States. The suit claims the feds had no authority to detain and question Lindell against his will, and that they violated his First, Fourth, Fifth, and Sixth Amendment rights. The Justice Department is investigating Lindell over potential identity theft and a suspected voting equipment breach in Colorado's Mesa County. Investigators say the cell phone seizure was to search for records or information connecting Lindell to Mesa County election clerk Tina Peters, who's been indicted for an alleged scheme to breach voting machines during the 2020 election. Lindell also faces lawsuits brought by 2 voting machine companies over his claims that they rigged the 2020 election. A North Dakota man is facing homicide charges, but was released out on bond for allegedly killing a teenager with his car after a political dispute. 41-year-old Shannon Brandt is charged with felony vehicular homicide for allegedly hitting 18-year-old Kayler Ellison with his car earlier Sunday morning. Brandt reportedly told troopers he felt threatened by Ellison and admitting to hitting the teen with his car because he had a political argument with him and believed he was part of a Republican extremist group. Brandt was given a breathalyzer test when he was arrested at his home and registered above the legal limit of 0.08. Brandt was released Tuesday from jail on a $50,000 bond after pleading with the judge that he was not a flight risk. His next court appearance for an arraignment is scheduled for October 11th. Terry, Brandt seems to be suggesting this vehicular homicide was in self-defense and over a political argument, no less. At this point, is that a working defense here?
You know, Brian, I don't see that as a viable self-defense argument. It's difficult to say that killing a pedestrian with a car could actually be considered self-defense. Even if Brandt thought the victim was calling people and they were going to attack him and he was getting ready, he had an opportunity to drive away. And based on all of the reports so far, it doesn't appear that he tried to get away. It appears as though the opposite was the case, that the victim was trying to get away. The victim was not posing any immediate danger. And so based on all that, I don't think that that's going to be a good self-defense argument for Brandt.
Yeah, I would agree as well. Richard, on top of that, Brandt's BAC was above the legal limit, but that was done hours after the incident. So is that going to harm any potential defense that he puts forward?
Yeah, I think it will, Brian. I mean, being drunk generally doesn't help you in any defense to a criminal charge. And it's not going to help here because if he's trying to say he acted in self-defense, his judgment about needing to act in self-defense was impacted by the intoxication. So that's not going to help him whatsoever. And it doesn't exonerate him. It doesn't offer him an additional defense to having, run the guy down. So I think it's a problem. It's certainly not a help.
Yeah, alcohol tends to kind of enrage people, and this seems like a killing out of rage. It's something the prosecution will probably try to really drive home. Well, coming up on Law and Crime Daily, a Houston father is gunned down and killed. His 2-year-old son found dead hours later in his stolen SUV. Now, a suspect is in custody. Plus, we head to the courtroom in Pike County where jurors are taken through a third crime scene in the trial of defendant George Wagner IV. Welcome back. A man is in custody and charged with 2 counts of murder after father and his young son were killed in Houston earlier this week. Police released the identity of the suspect, Bolan Lee Fodero, earlier Thursday morning after an investigation into the deaths of his father and his 2-year-old son, Micah, led to his arrest. Michael Essien was gunned down on Tuesday at a gas station. Investigators say Fodero stole his SUV with his 2-year-old son inside. The car was found hours later, just a couple of miles away, but police were too late. Essien's son was left alone inside the hot car for hours. He was found dead from what officials believe was heat exhaustion. Fodero has reportedly known Essien for 30 years. Essien leaves behind a wife and 2 other children, including a week-old baby. Fodero made his first appearance in court Thursday and is being held on a $750,000 bond. Fodero is charged with the death of 2 people, including a 2-year-old, but they died in very different ways. So how will the charges differ in prosecuting him?
Well, they are related homicides, obviously, but I do think the charges are going to be very different. Obviously, authorities are still just gathering all the information, but based on the information so far from the witnesses, the surveillance cameras, it does appear that the suspect intentionally, obviously, shot and killed the father. But as far as the baby's concerned, I'm assuming he knew the baby was in the car and he left the child in the car. I think there could be murder charges. There could be, manslaughter charges, perhaps because it might not have been intentional. But either way, I think when they find the suspect, he really should be held accountable for these horrible deaths.
Yeah, they could also probably throw a felony murder at him for the death of the child. But Richard, in New York, we have Leandro's laws for driving while intoxicated with a child passenger. You could face higher penalties. So do you think we could see new laws coming from the death of the 2-year-old victim in a similar situation here?
It might be a good idea. I mean, this is a perfect example. Carjackings are a problem in this country from time to time, and they not only cause the obvious harm of taking the car, but they can create adverse consequences like this horrible tragedy. He probably didn't know there was someone in the back seat and he was leaving him, but because he committed a crime, he was creating the opportunity for something bad like that to happen. And I think maybe we do need some statutes that address that.
Yeah. Well, we'll see how this case continues. Again, just a recent arrest. We will follow the story on Law and Crime Daily. When we come back, testimony in Ohio's Pike County massacre case moves on to the third crime scene as defendant George Wagner IV stands trial for several charges, including murder. Welcome back to Law and Crime Daily. A suspect turns himself in days after a home invasion of an elderly couple in Virginia is caught on camera. Take a look.
Get in the crib. Don't say nothing. Don't say nothing. Y'all get in the closet. Get in the closet right now. Get in the closet. I'm not playing. Get in the closet right now. Get in the closet. Hurry up. Get up. Get up. Get up. Get up. Get up. Not playing. Hurry up. Get up. Hurry up. Get up. You good. Come on.
Police say the men in the video are Mitchell Boney Jr. and Tyree DeMont Boney Jr. The suspect stole only a wallet and a safe. Days later, one of the suspects, Mitchell Boney Jr., turned himself in. He's charged with armed robbery, use of a firearm, abduction, and conspiracy to commit a burglary. And switching to Ohio, where testimony moves on to a third crime scene in the Pike County massacre trial of defendant George Wagner IV. Jurors heard from a former investigator with the Ohio Bureau of Criminal Investigation first thing Thursday morning, shortly after the defense was denied a second motion for a mistrial in just as many days over the bloody photos out of each crime scene and autopsy photos being shown in court. This comes as George Wagner IV is being tried for the execution-style murders of the Roden and Gilley families back in 2016. George, along with his brother Jacob and their parents Billy and Angela, are all accused of having a part in the killings, which investigators say stemmed from a custody dispute involving a child Jake had with Hannah Gilley. On Thursday, former BCI agent Brian White took the stand to testify about processing the third crime scene, the trailer where Dana and her 2 children, Hannah Mae and Chris Roden Jr., were killed. He told jurors in detail about the 3 bedrooms where each body was found, as they were shown photos of each victim. He described the graphic images shown on Dana's body.
Can you tell us what that item is?
That's item number 6, which is what we just saw. So that was the pillow that was covering her face. And all that's documenting is when the pillow came off of her face, documenting what the pillow looked like.
There appears to be, obviously blood.
Yes.
But then other material that is kind of more in the center of that photo. Can you tell us what that is?
Blood, tissue, and it's very common in gunshot wounds to have tissue or other matter, brain matter, whatever, can ooze out of the actual bullet holes themselves. So that's what we've got going on there. Or the mouth, any opening, nose, ears, you name it.
Okay. But there was not any bullet holes that went through that pillow?
No, there were not.
All right, Richard Schoenstein, the defense moved for a mistrial again this morning. Why so many, and did this one have any merit?
Well, why so many is because there's so much gruesome evidence in this case. There's an endless barrage of photographs and other graphic evidence of these crime scenes, and they don't all prove that this defendant is tied to the murders at all. So at some point, the prejudicial value clearly outweighs the probative value of this. This particular motion was probably proper denied because it hasn't gone over the edge yet. But, you know, defendants are going to keep making these motions. There's no cost to making a mistrial motion. And their objective here is to either get an acquittal or to create appellate issues that would allow a conviction to be overturned. They're going to tend to make every motion they can. They're going to pile up the mistrial motions, even if none of them in and of themselves are meritorious enough to carry the day.
All right, Richard, thanks for that. That's kind of like the big picture of this, especially looking beyond for the appeal. So, Terry, let's dig down a little deeper. The defense made at least one objection, I think that Richard kind of touched on, that seems really interesting. Why show evidence of a crime scene where you can't prove the defendant was there? Could there be grounds for an appeal, or is there something else that's going on here?
Well, you know, I think that evidence, I agree with Richard, is not enough for a mistrial. And I think that evidence is not enough for an appeal. But it does make sense. It's a very reasonable objection. I think that it could be more prejudicial than probative, but I think it is related. He is also charged with conspiracy and tampering with evidence. So showing those crime scenes is very relevant.
All right, we'll see how this goes, both with this case and potential appeals. Thank you, Richard and Terry. And thank you for joining us here on Law and Crime Daily. We'll see you next time as we discuss justice in America.